CSIR, New Delhi. President, KMV IIC, Dr. Rashmi Sharma. Head PG Department of Chemistry, Dr. Manju Sahni. Coordinators and members IIC from our 5 mentee institutions: GHG Institution for Law, Ludhiana, JSC DAV College, Dasua, LN College of Technology Excellence, Bhopal, IITM College of Science, Arts and Commerce, Haryana, Government College, Ropar. It is a matter of great pride for us that these institutions have selected us as their mentor to guide them on various aspects of innovation and entrepreneurship. I, Dr. Narinderjeet Kaur, IPR Activity Coordinator, KMV IIC, welcome you all on the behalf of whole KMV family on this day 3 of workshop on IPR and IP Management for Startups organized by KMV IIC in collaboration with PG Department of Chemistry and IQSC Kanya Mahavidyalaya for our mentee institutions. Kanya Mahavidyalaya, a multi-faculty postgraduate pioneer institution, has been accredited A grade by UGC NAC, awarded the status of college with potential for excellence, star college status by DBT Government of India, top national rankings as per India Today, and ranked #1 autonomous college in Punjab by Outlook magazine for the last 3 consecutive years. It ceaselessly strives to open up new vistas of learning and to emancipate, enlighten, and empower women. KMV is working continuously to foster innovative and entrepreneurial culture among students, and promoting innovation and entrepreneurship is at the core of every activity performed by various departments. KMV IIC is performing well in terms of conducting innovation and entrepreneurship activities and successfully developed the support system and competencies to drive the campus ecosystem efficiently. It is a matter of great honor that Ministry of Education Innovation Cell has recognized KMV as a high-performing IIC institution, star rating of 4.5, to act as mentor to the IIC institutions those are in need of guidance and support. KMV is among the top 155 institutions all over the country to be selected as mentor institution as part of mentor-mentee program of MOE's Innovation Cell. This twinning program will help KMV and its mentee institutions to facilitate knowledge exchange and resource mobilization between institutions by offering inter-institutional collaborations. So it is one of the very few institutions all over the country to be conferred 4.5 and 4 gold stars, that is highest rating in the country by Ministry of Education, Government of India. I would like to thank Dr. Rashmi Sharma, President KMV IIC, and her team for continuously working and taking KMV IIC to great heights. She is always a support and motivation for us to do such endeavors. So now, not taking much time, I would like to invite Dr. Shikha to introduce and welcome eminent speaker of the day, Dr. Seema. Over to you, Shikha. Dr. Shikha.
A very good afternoon, everyone. I feel elated to welcome and introduce the speaker of the day, Dr. Seema, who is going to talk about IPR and IP management. Dr. Seema has done her doctorate from DDU Gorakhpur University in 2007. She was awarded with Rajiv Gandhi Postdoctoral Fellowship. Along with, she was also selected for the other postdoctoral fellowships from various renowned organizations. She is currently working as Scientist C in CSIR from 2017. Previously, she was working as Group A Gazetted Officer in Ministry of Commerce and Industry, New Delhi from 2009 to 2017. She has also visited Japan Patent Office for IPR training course in 2014. She has delivered many invited lectures on IPR and chemistry at various organizations such as IIT Mumbai, Indian Patent Office New Delhi, Indian Institute of Science Bengaluru, and so on. She is also the member of Indian Council of Chemists. Dr. Seema, it gives us immense pleasure to have you with us as we have been eagerly waiting to hear you. So we welcome you, ma'am, and the platform is yours now. Over to you, ma'am.
Thank you very much, Dr. Seema. Please share my slide.
Is it visible?
Yes, ma'am.
Okay. So, ma'am, should I convert it into slideshow?
Yeah.
Okay. Yes, ma'am.
Yeah. My topic is a patent structures and filing processes. Next, ma'am. The agenda of this presentations is IP Office, Patent Office, Patent System, Patent Drafting, Working Example, and Benefits. The Patent Office situated. The Patent Office come under the Controller General of Patent Design and Trademarks. The Patent Office situated in Kolkata office. Kolkata office is head office. New Delhi office, Chennai office, and Mumbai office. And second is trademark registry. The trademark registry is situated in Mumbai. Mumbai office is head office. And the second is New Delhi, third Kolkata, fourth Chennai, and Ahmedabad. Design being situated in Kolkata. Geographical indication registry only in Chennai. Copyright office in New Delhi. And semiconductor layout design in New Delhi. And RG and IPM training centers in Nagpur, and intellectual property appellate board only in Chennai. Next, ma'am. This slide shows the IP buildings. Kolkata office, Delhi office, Chennai office, and Mumbai office. Next, ma'am. The RG and IPM. The Rajiv Gandhi National Institute of Intellectual Property. Ma'am, previous slide. RG and IPM. The Rajiv Gandhi National Institute of Intellectual Properties Management is a central government institute under the Ministry of Commerce and Industry, and conducting the training awareness program relating to intellectual property rights, IPRs, patent design, geographical indications, and trademarks. Next slide, ma'am. The geographical locations of Ministry and IP offices. Patent office and Kolkata office, and patent information systems, Nagpur, and offices CGP, DTM. Next, ma'am. If I have invention and I don't have idea about how to protect in market, then I will confuse. So if I want to protect my inventions in public in country, then we should know what is patent, what is design, what is copyright, what is geographical indication, what is trademark registry, what is trade secret. If my invention related to the patent, then we will go to the patent office. If my invention is related to design and related design technique, then I will go to design, and then my invention is protected in the design office. Same is copyright, geographical indication, trademark, and trade secret. Next. It is what is your idea? It is just an idea only if it is an innovative idea, as an idea has been converted into an application to process your product. If yes, what is that? If not, please do not waste time and convert the same to same process or product application at the earliest before anybody does it. Next, ma'am. Idea need to express in writing only, not in oral, not in thinking forms. Next one. Analyze your innovative idea. It is a completely a novel concept. It is a modifications to existing products, device, articles, or machines. Does your invention relate to the technical application? Does it relate to aesthetic creation or the existing products? Next. If your invention is related to the technical application, it has been protected by the patent under the patent law 1973. It is related to aesthetic creation of the existing product. It has been protected by design under design law. Next, ma'am. What is patent? A patent is intellectual property right relating to invention and is the grant of exclusive right from the time limit period. That time limit period is 20 years from the date of filing. In exchange of full disclosure of his invention or exclusive other from making, using, selling, importing the patented product or process produce the product for those purpose. Next one. What is patent? A patent is a statutory right to the inventor or the applicant by the government of his invention, which is either a new product or process. It is for a limited time period, that is 20 years. It is granted in lieu of sufficient disclosure to the patent office. It is granted to prevent other from sufficient disclosure to the patent office. It is granted to prevent other from doing certain act without authorization from the patentee. It is only territorial right. Next one. Basic criteria of patentability. The basic criteria of patentability novel, involve inventive step and capable of industrial application. That is three most important things for the filing of the patent application in patent office or a patent in India. Next one. What is an invention? According to Indian Patent Act under section 21J, the invention means a new product or process or involve inventive steps and capable of industrial applications. Next one. Invention must not be published in India or elsewhere. That is the most important thing for the patent application filing in India. In prior public knowledge or prior public use within India, claim before any specification in India. Next one. What is new invention? A new at the date of filing of the patent applications. It means the complete novel, not disclosed anywhere in anywhere oral presentation, paper presentations, any other magazine, etc. New, it is not from the prior art, the state of the art. State of the art means everything is made available to the public by means of written or oral disclosure or used in any other way before the date of filing of the patent applications. Next. Written disclosure, for example, patent applications are also those still secret but filed before the filing date of the application, internet, letters, emails, posters, abstract, thesis. Next one. Oral disclosure, lecture to be in conference, just like so in my slides, thesis discussions, meeting at least 2 persons, a conversations or the lecture or by the means of the radio, television or sound reproductions, equipment, tapes and records. Next. What not do when consider the filing the patent application? No publication prior to the filing, for example, articles, press release, conference, presentations, posters, processing block entries, no sale or product incorporating the invention prior to filing, no lecture or presentation prior to filing, except under the non-disclosure agreement NDA, seek patent professional advice soon, file before other do. Next one. Inventive steps, a feature of invention that involve a technical advance as compared to the existing knowledge. The question is the inventive steps only areas if the invention is novel, and invention is considered to involve inventive steps are non-obvious person skill in the art. When relative to the prior art, the invention would not be obvious to a person skill in a particular field in the technology. It means the अगर कोई person जैसे कोई है, for example, can I speak in English and Hindi both?
Yes, sure, ma'am. Yes.
अगर कोई person है जैसे chemist है, तो chemist तो वो जानेगा ना कि alcohol से aldehyde से acid बनेगा, तो वो तो person skill in the art हो गया. तो वो पर्सन स्किल इन द आर्ट जो है वो पेटेंटेबल मतलब एक इंपॉर्टेंट थिंग ऑफ क्राइटेरिया ऑफ द पेटेंट एप्लीकेशन. ओके मैम. The term obvious means that which does not go to beyond the normal progress, natural evaluations or technology, but merely follow plainly logically from the prior art. That is something which does not involve an exercise of any skill ability beyond the accept of the person is in the art. Next one. Previous. Industrial application. Invention is capable to being made used in any kind of industry. Patentability subject matter. Any article, apparatus, or machinery or its components. Patentable subject matter. Any substance where living or non-living products, pharmaceutical products. Any compositions of matter, pharmaceutical products. Any process, manners, or art manufactured other than essential biological process. Next one. What is not patentable under section 3A? Invention which is frivolous or which claim anything obvious contrary to well-established natural law. For example, natural law, Schrödinger wave equations is not patentable. Next one. 3B. The invention that primary or instant used a commercial exploitations or which could be contrary public order or morality or which cause serious prejudice to human, animals, plants, life, health to the environment, injurious to public health. For example, अगर हम किसी चीज से किसी लिविंग थिंग को अगर हम हैजार्डस होता है तो वो पेटेंटेबल नहीं होता. फॉर एग्जांपल सिगरेट स्मोकिंग है, अल्कोहल लेना, इस टाइप का जो है सब्जेक्ट मैटर जो है पेटेंटेबल नहीं होता, injurious to the public health. According to 3C, the mere discovery of scientific principle or the formulation of abstract theory, discovery of any living, non-living substance occurring in nature. Next, for example, 3 is equal to mc square, Schrödinger wave equations is not patentable because it is the base of physics. Okay, and next one. What is under section 3D? The most important thing is sections of 3D according to Indian Patent Act for chemical cases. The mere discovery of new form of known substance which does not result in the enhancement of the known efficacy of that known substance or the mere use of known process, machine, apparatus unless such known process result in a new product or imply at least new reactant. Next one. For explanation, salt, esters, ethers, polymers, metabolic, pure forms, particle size, isomer, mixtures of isomer, complexes, combinations, and other derivative of known substance shall be considered to be the same substance unless they differ significantly in property with regard to efficacy. Next one. According to 3E, a substance obtained by a mere admixtures resulting only in the aggregation of the properties of the component thereof the process for the producing substance is not patentable under section 3E. If अगर हम composition का अगर हम देंगे कि synergistic effect data देंगे तब वो patentable होगा. Okay. Next. Section 3F, the mere arrangement or rearrangement of duplication of known device, each functioning independently of the another is known way. Next, ma'am. According to section 3H, any type of agriculture method, a method of agriculture, horticulture is not patentable. Section 3I, according to section 3I, any process for the medical, surgical, curative, prosthetic, diagnostic, therapeutic, or other treatment of human being, or any process for a similar treatment of animals to render them free to disease to increase their economical value, or that their product is not invention. Under this section, the Manual of Patent Office Practice is procedure that the following are is not the patentable: removal of cancer, removal of dental, surgical process relating to therapy, method of vaccinations, and blood transfusion. In any method of treatment of animals renders them free of disease to increase their economical value, or that their product, for example, a method of treating sheep for increasing the yield wool, of method of artificial, including the body mass polarity. For example, a substance excluding other than previous are the operations of the body which require the skill and knowledge of the surgeon and include treatment such as a cosmetic treatment, the treatment of pregnancy and sterilizations, artificial inseminations, embryo transplantations, and treatment of experimental and research purpose, and those removal of organs, skin of the bone marrow from the living donors, and therapy of diagnostic practice of on the human and animal body, and further includes the method of abortion, including labor control, menstruation regulations is not patentable under section 3I. Under section 3J, the plants and animals in whole are any parts there of the other the microorganism, but the including seed variety, species, essential biological process for production or propagation of plants and animals. For example, अगर हम कोई एनिमल ले ले, चाहे जो भी एनिमल ले, चाहे एलिफेंट हुआ, हॉर्स हुआ, वो पेटेंटेबल नहीं होता है अकॉर्डिंग टू 3J. अगर हम कोई कहे कि नहीं ये मेरा है तो ये मुझे पेटेंट कराना, तो ये अंडर सेक्शन 3J के अकॉर्डिंग पेटेंटेबल नहीं होगा. नेक्स्ट मैम, सेक्शन 3 के ए मैथमेटिकल या बिजनेस मेथड या कंप्यूटर प्रोग्राम एज पर द एल्गोरिथम इज नॉट पेटेंटेबल अंडर सेक्शन 3K. नेक्स्ट, 3L, literacy, dramatic, musical, artistic works, or any other aesthetic creations whatsoever, including cinematography work and television productions. For example, any violin type of violin and गिटार बजाना, चाहे म्यूजिक सिंगिंग करना, इस टाइप के जो होते हैं मैटर जो होते हैं वो पेटेंटेबल नहीं होते हैं अकॉर्डिंग टू 3L. नेक्स्ट, 3M, a mere scheme, rule, method of performing mental act, method of playing game is not patentable. 3M. Next, ma'am. According to 3N, any type of presentations, informations, type of presentations is not patentable. Next, ma'am. According to 3O, the topographical integrated circuit is not patentable. According to 3P, traditional knowledge aggregations or duplications of known property of traditional known component. Traditional knowledge is not patentable under section 3P. Next. According to section 4, no patent is granted in respect of the invention relating to atomic energy, falling within the section 4. According to these sections, the atomic energy means energy released from the atom nucleus and result any process including the fission and fusion process. Under this act, the prescribed substance means any substance including any mineral which the central government may be notifications prescribed being substance which opinion in may be used production or atomic energy or research. The updated list of prescribed substances in atomic energy in 1962. In atomic energy, uranium, beryllium, thorium, plutonium, radium, graphite, and lithium, and more is not patentable. A process of patenting. Be curious, but do not disclose your invention. Keep a bound notebook to prove when you got the idea. Develop the idea and produce a model. Write why your invention is needed, what is the existing product are in the market, your new product, and what is unique about your product. That is important thing for the patent applications. Next, important to remember, do not publish or disclose your invention publicly before filing of the patent applications. Do not commercially work your invention publicly before filing the patent application. Any forms of prior publications or disclosure or the commercially work with will amount to anticipate of the invention resulting into loss of novelty. In case it is published, try to application it file earliest. The act provided grace period is 12 months. Filing of application, there is two types of filing. First is online and second is hard copy. Document can be filed in patent office, electronically filed through IP India, ipindiaonline.gov.in, and physically filed at the office counter by the post or by the post can be submitted by hand. Next, this is the patent website. This slide. Next one. On the basis of jurisdictions, the patent office file Northern State Patent Office Delhi, Southern State Patent Office Chennai, Western State Patent Office Mumbai, Rest of India Patent Office Kolkata, and foreign application based on the address for service in India. Who can apply? The application can be filed either along or jointly. The inventor, by any person claiming to be true and first inventor, assignee of the inventor, the natural person, the legal entity, the company, university, etc. By any person being the assignee of person claiming to the true and first inventor, by the legal representative of any desired persons of the assignee. Document required at the counter. This slide shows for the counter. A covering letter, a duly filed in application form 1 in duplicate, information regarding foreign filing of form 3, and proof of right to the apply in the inventor is not applicant, prescribed fee as per the first schedule in cash या draft में कर सकते हैं. Patent specification, two type of specification, patent provisional and complete specification in form 2, and declaration as the inventorship in form 5, and abstract about 150 words, drawing, and the power of attorney. Next one. The application for the patent, the most important thing for the complete specification, abstract, drawing, claim, disclosure of embodiments, and introductions. Next. There are two types of application. First is provisional application and second is complete specifications. Next, the provisional specification. This is filed when the application applicant feel that the discovery idea and research state that it can be disclosed in the form of the written report. In this case, the provisional application is submitted to the patent office and is helped to preserve the priority date of the application. After the receiving the provisional specification, the patent office give an application number to the patent applicant. Provisional specification secure. The main important thing for the filing of the patent provisional specification is the secure the priority date. Next, ma'am. Complete specification, the complete specification, the main important thing is page 1, cover page, form 2, title of the invention, address, nationality, applicant, or preamble. A second page onwards, field of invention, background of invention, prior art, advantage over the prior art, summary of the invention, statement of the invention, detailed description of the inventor, working example, and claims, drawings, and abstract. The content of the application. Content of patent writing है, title है, field of invention, background of inventions, object of the invention, summary of the invention, brief description of the drawing, detailed description of inventions, claim, figures, and abstract of title. The title shall be brief, free frequency, expression, ambiguity, and a precise and definite as possible, not exceeding 15 words. 15 words से ज़्यादा आपकी title नहीं होनी चाहिए. Field of invention. Previous slide. Field of invention. Field of invention should tell the advantage of the invention, provide evidence to the support industrial applications. Background of the invention and prior art. Background of the inventions, shame as literacy survey describe the inventions by clearly distinguish it from the closest prior art. And object of the inventions, they shall clearly mention the technical problem associated with the existing technology and the solution for that, bringing out the difference between claim invention and the prior art. And summary of the inventions. Summary of the invention should include the summary of invention brief before giving the detail of the invention and the method performing it. Brief descriptions of the drawing. What different figure tell us about the invention. For example, figure 1 and 3D model is proposed. Detailed description of the invention describe the invention is required to the furnish with the sufficient detail as the given complete picture of the invention, bullet point and precise. And claims, very important part of the patent writings. Claim is a statement of technical fact expressed in legal terms, defining the scope of the inventions, how to be the protected, what is not claimed, and claim extent disclosed is open to public use even if the matter is described in the specifications. Figures shall be on A4 size sheet and clearly margin at least 4 centimeters from top and 3 centimeters from the bottom right hand to the every sheet. Abstract should not more than 150 words. Abstract is gist of the complete specifications of your applications. Next. Title should be sufficient, indicate the subject matter of the invention and disclose the specific features of the invention. It need not to be the same as preamble of the main claim. It shall be brief, free from fancy expressions on ambiguity, and precise and definitely possible. It is need to not go into the detail of the invention itself. The word new, improve, improvement, and examples, for examples, not used in the title. Field of the invention, the describe should be preferably begin with the general statement of the invention, so the indicate briefly subject matters to which the invention relates. For example, the invention relate to there. The advantage of the inventions may be mentioned to bring our clearly an area application preferably use the invention. The applicant may substance industrial applicability of the invention in this part. State of the art. This part should be indicate the state of technology in the field of the invention, which with reference to the development of the field, including patent and patent application in specific spot. When the invention relate to improvement over the existing products, your process, your short statement, closest prior art knowledge to the application in respect to shall be also given. However, the describe should fully particularly describe the invention by clearly in such a closest prior note to the applicant. Object of the invention. The purpose of these parts is clearly bringing out the necessity to do invention. It shall clearly mention the technical problem associated with the existing technology and the solution for that, bringing out the difference between the claim invention and the prior art. The solution sought with the invention should be clearly brought out as object of the invention with the statement like the principal object of the invention is, the another object of the invention is, a further object of the invention is, etc. Next. Summary of the invention. The subject matter of the invention should be described in one or more clear, concise and sentence and paragraph. The summary is properly written to set out the nature, operation and purpose of the invention will provide great assistance to seeking to understand the invention and what is the patent cover in the future. This is true because the summary written in plain, easy to understand terms, the summary instinct the straightforward and not particularly written legalized. The summary of the invention should be considered with the claim invention and should be more than a mere statement of the object of the invention, although a statement about the object of the invention and permissible. Next. Detailed descriptions furnish insufficient detailed invention reference drawings, clear, intelligent language about the inventions. Next, ma'am. Next. A main component of the descriptions is a description should be clear, intelligent language about the invention. A main component of the description should be disclose the manner in which invention is to be performed so that other may know how to avail the invention when patent expire, how to carry out the new invention. Best method to be disclosed need not to be claimed. To be defined clearly and precisely in exclusive right monopoly required. To define the scope of the invention, to define various necessary, perform and optional features of the invention, to limit and not extended the monopoly being granted. Next. Biological matters. In this case, biological matters, the description of the specification is not available to the public and cannot be described. As per the provisions of this Act, such materials shall be depository in order to make the application completely with International Depository Authority under the Budapest Treaty (MTCC), which is situated in the Chandigarh. And if there is any request for early publication, then the said reference shall be given on the before and date of filing of the such request, source and geographical origins. The last thing is a source of geographical origins. Claims. The main important things in the patent applications is a claim. Claim is the heart of the patent applications. The important thing is the claim should be fairly based on matter disclosed in the specification. First claim is called the principal claim and subsequent claim is called the performed embodiment. Principal claim should be defined all essential novel features with their interconnections. Operation features may be given in sub-ordinary claim. The claim should be required under section 2(1)(j), 3, 4 and 10, and claim may be same in numbers. Claim should be clear and concise. Claim should be related to a single inventive concept according to Indian Patent Act 10(5). The claim should be consist a single sentence. Claim exceeding 10 pages chargeable per claim is per claim. Format of the claim to be avoided. I claim to be inventor of the applicants. I claim that machine described above is quite new and used before. I claim some reward. I claim this device is better than more effectively than any other things. I claim following advantage. Next. Drafting of the abstract. The purpose of the technical important presented by the brief means everything analyzed in the describe the claim drawing. What should be mentioned? The title of the invention, the technical field to which the inventor pertain, a reference to the manner or solving the technical problem the invention details with, the main use or uses, the basic chemical formula. The next ma'am. Next. The drawing should be represented visual representations. This particular requirement of mechanical invention that describe a function of the apparatus by referring to the references number in figures, although clean and line clear, it performed a simple hand drawing may sufficiently to purpose the inventor disclosure. Next, although labeled photographs, although the label are used here, refers the number may also be used and the label may be hand drawn. They say the pictures is worth in 1,000 words, and that is true and here too. Next, ma'am. This is way to the figure representations. A simple method or process inventions can be visualized in this manner. Next, ma'am. Next. The chemical representations. In chemical cases, pictorial representation reaction may be crucial in helping the readers understand the inventions. Step from filing to the grant of patents. First, filing the patent applications provisional are complete. After 18 months, it has been published. Publications of the application under section 11A. After that, the applicant has request to examine the applications in Form 18. Request for examination. After that, examination and communication to the applicant in form of FER. In between, within 6 months, the applicant has to reply the objections. If the reply by the applicant is satisfactory, the application is granted, and after that, the letter patent has been raised by the patent office to the applicant. Within 1 year, anyone can oppose the application. That is called the post grant oppositions. Next one. Fee. The provisional application here complete. Individual 1,600 and company 18,000, and page exceeding 30, individual 160 and company 800, claim exceeded 10, 320 individual and company 1,600, request for extension of time and in form 480 per month and 2,400 per month for company, and request early publications in form 9, 2,500 individual and 12,500 for company, and request for examination in form 18, individual 4,000 and company 20,000, and express request for examination in form 18, 5,600 and 28,000. Next. Obtain a patent, filing the application of patent with one of the patent office based on the territorial jurisdiction of the place of office or residence of patent agent, pay the required fee. Information concerning applications from the detailed fee available ipindia.nic.in. Guidelines of the applications are available on the website. Next one. Website. This slide shows the website of patent office. Next, publication. Application is kept secret for the period of 18 months from the date of filing. अगर हम अपना केस फाइल करते हैं तो 18 महीने तक वो सीक्रेट में रहता है पेटेंट ऑफिस में. In 19 months, the application is published in the official journal. This journal is made available in the website weekly. फ्राइडे को ये वीकली पब्लिश हो जाती है पेटेंट ऑफिस की वेबसाइट पे. Application has to obtain a this application published before 18 months also. In this case, application is published within 1 month from the of the request. This is Gazette notification. Next, formality check. An examiner check the formal requirement before accepting the application and the fee. This is done immediately. Issue the application number and cash receipt. This is done on the same day. In case the receipt of the application by post, cash receipt application number is sent by the post within 2 to 3 days. Request for examination. Application examined on request. Request for examination can be made either by the applicant or by the third party. The period of 48 months from the date of filing is available for making request of examination. Informative. Next one. Exam application is sent to the examiner within 1 month from the date of request for examination. Examiner undertake the examination with respect to the whether the claimed invention is not prohibited for grant of patent. Section 4, atomic energy. Whether the invention meet the criteria of patentability. In Section 3, Section 4, and issue of IPR. A period of 1 to 3 months is available to the examiner to submit the report to the controller. First month time available to control the weight the examiner report. First examiner's report is containing the gist of the objection. Next one. This is the first examiner's report issued by the patent office. Next one. A response from the applicant. 6 month time from the date of issue of the FER is available to the applicant to meet the objection. If objection are made, the grant of patent is provided by the controller within a period of 1 month. Pre-grant opposition after a publication and oppositions can be filed within a period of 6 months. Opportunity to hearing the opposition is also available. After examination, opposition and the submission made during the hearing, controller may be either rejection opposition and grant upon a patent, accept the opposition and modify reject the patent applications. Grant of patent. A certificate of patent is issued within the 7 days. Grant of patent is published in the official journal. Benefit: stop reinvention, know what is already patented, patent collaboration, money, fame, name, etc. Technology development. Next one. Benefit: a patent give us the ability to take illegal action to try to stop other from copying, manufacturing, selling, importing your inventions without your permission. The existing of patent may be enough or it won't stop other trying to exploit your inventions. If it does not, the patent give you the try to take a legal action under the civil law to try to stop them exploitation your invention. The public you also benefit from your patent because we publish it after 18 months. Other than can gain advanced knowledge of technical development which they will actually be able to use freely once the patent cases. What not a patent do? If protect invention probably 20 years, no one else to manufacture the product. 20 years तक कोई दूसरा कोई आपका manufacture नहीं कर सकता. ये plus भी और minus भी है. Someone can pay your royalty. You can block competitor. After 20 year technology go to public domain. After 20 year ये जो है public कोई भी आपका use कर सकता है क्योंकि वो उस patent का right नहीं हो सकता. Public domain में आ जाता है. It will become in public domain for the all public. Sell the invention and all intellectual property IP. License the invention to some else but retain all the IP rights. Discuss the invention with other in order to set up the business based around the inventions. Next one. What if you do not patent your invention? If you do not patent your invention, anyone can use, make, sell, other stop in invention and you cannot try to stop them. कोई भी आपको invention चुरा लेगा और आप कुछ कर नहीं पाओगे. तो इसका benefit ये है. Thank you. My slide is complete. It's too early.
Thank you so much, ma'am. So if anybody from the participant is having any query, and before that, I would like to acknowledge the presence of Dr. T. Pavan Kumar between us. So Shashi sir, could you please add a spotlight on him? So are you there?
Yes, I'm here.
Yes, sir. Yes,
I'm here.
So
good afternoon
sir,
to all.
Welcome on third day also.
Thank you.
Thank you, sir.
I hope, hello, Dr. Seema.
Hello, sir.
So hope the program is up to the mark. Like it might have reached to the expectations. Maybe sometime later we can have a session on patent filing processes. Or Seema ji, if we can quickly, in very few minutes, if we can quickly outline the patent filing process, it would be very much helpful to the audience present here.
Okay. With my slide or without slide?
No, without slide is also fine. No, if you have slide, it with slide is also fine. Anything is fine, up to you.
Okay. Just a minute.
Huh.
Step filing step, na sir?
Yes, yes. Process.
There are two type of specification, complete and provisional. अगर आपके पास इन्वेंशन जो है अगर कंप्लीट है या प्रोविजनल एप्लीकेशन है, तो आप क्या करोगे कि उसको उसकी प्रायोरिटी डेट जो है उसको सिक्योर करने के लिए, जैसे आपके मन में कोई इन्वेंशन आया और आप चाहते हो कि आपका इन्वेंशन जो है अभी कंप्लीट नहीं है या जो एक्सरसाइज है अभी कंप्लीट नहीं है, आप क्या करोगे एक लिस्ट बना के उसको प्रोविजनल एप्लीकेशन के रूप में पहले क्या करोगे पेटेंट ऑफिस में फाइल कर देना है। और इसको करने से क्या होता है कि मेरी प्रायोरिटी डेट उस डेट से काउंट हो जाती है और हमको क्या करता है 1 साल का टाइम मिलता है। जैसे मान लीजिए आज के डेट में हम किए 14 मार्च को किए, 14 मार्च 2022 को, ठीक है, तो हमको 14 मार्च 2023 तक का आपको टाइम मिलेगा कंप्लीट स्पेसिफिकेशन फाइल करने के लिए। आप अपना एक्सरसाइज कंप्लीट करके उसको फाइल कर सकते हो। अब उसका प्रोसेस क्या है कि हम अपना जो है एप्लीकेशन जो है फॉर्म 1, फर्स्ट जो मेन इंपॉर्टेंट थिंग फॉर एप्लीकेशन इज फॉर्म 1, फॉर्म 2, फॉर्म 3, फॉर्म 5 एंड फॉर्म 5। ये 4 एप्लीकेशन 4 फॉर्म जो होती है बहुत इंपॉर्टेंट होती है जो कि पेटेंट फाइल करना होता है। तो हमको फॉर्म 1 में क्या होता है कि पूरा एप्लीकेंट का नाम, एप्लीकेंट का करस्पॉन्डेंस एड्रेस, ये सब उसमें फिल करना होता है और उसके साथ क्या उसमें ये मार्क करना होता है कि मेरा जो है स्पेसिफिकेशन कंप्लीट है या प्रोविजनल है। तो उसके बाद क्या करेंगे, उसके बाद फॉर्म 2 फाइल करना, उसके साथ हमको फॉर्म 2 भी करना होगा। जो फॉर्म 2 होगा मेरा प्रोविजनल, अगर हम प्रोविजनल की बात कर रहे हैं प्रोविजनल करेंगे तो प्रोविजनल में हम सब देंगे कि फील्ड ऑफ इन्वेंशन, बैकग्राउंड ऑफ इन्वेंशन, एग्जांपल एंड विद इन 30 पेज। उसमें क्लेम तो रहेगा नहीं क्योंकि अभी मेरे पास पूरा जो है एक्सरसाइज कंप्लीट नहीं है। तो हम क्या करेंगे कि उसको एब्स्ट्रैक्ट के साथ हम फॉर्म 2 कंप्लीट कर देंगे एज ए प्रोविजनल एप्लीकेशन। फॉर्म 3 है कि अगर उसको बताना होता है मुझे कि मेरा एप्लीकेशन जो है अब्रॉड में फाइल होना है कि नहीं, अगर हम नहीं कर रहे हैं तो वहाँ मिल जाएगा, अगर जाना है तो हमको उसमें देना पड़ेगा डिटेल कि हम कहाँ पे अब्रॉड में फाइल करना चाहते हैं। फॉर्म 5 है इन्वेंटर। जितने भी इन्वेंटर है उनका डिक्लेरेशन ऑफ इन्वेंटरशिप होता है कि उसमें फॉर्म 5 की सारे इन्वेंटर एग्री हैं कि हम प्रोविजनल फाइल कर रहे हैं और ये उनका एक कंसेंट रहता है। तो उसमें फॉर्म 5 के रूप में डिक्लेरेशन ऑफ इन्वेंटरशिप उसका फॉर्म 5 का नाम है। तो वो ये फॉर्म करके हम पेटेंट ऑफिस में, अगर हम इंडिविजुअल कर रहे हैं तो 1600 रुपये लगेगा, अगर हम कंप्लीट एप्लीकेंट या कंपनी की ओर से कर रहे हैं तो 8000 लगेगा। तो वो करके पेटेंट ऑफिस में हम चाहे तो ऑनलाइन भी कर सकते हैं या हार्ड कॉपी भी सबमिट कर सकते हैं। अगर ऑनलाइन करेंगे तो IP India के साइट पे जाकर के हम उसका विंडो खुलेगा, उसमें पहले हम भरेंगे फॉर्म, उसको एक ही साथ करना होगा। उसमें फॉर्म 1 पहले फिल करेंगे, सबका PDF बना लेंगे पहले, फिर फॉर्म 1 कर लेंगे, फिर फॉर्म 3, फॉर्म 5 उसको अपलोड करके उसको सबमिट कर देंगे। तो उसके बाद हमको आ जाएगा CBR जो आ जाएगी तो उसमें आपको एप्लीकेशन नंबर, डॉकेट नंबर और CBR नंबर तीनों रहेगा। अब वो हम मान लीजिए आज हम फाइल कर देते हैं तो उसके 12 मंथ का टाइम होगा हमको कंप्लीट फाइल करने के लिए। कंप्लीट फाइल करने के टाइम भी मुझे यही प्रोसेस करनी होगी, फॉर्म 1, फॉर्म 3, फॉर्म 5, और उसके साथ हमको क्या करना होगा, रिक्वेस्ट फॉर एग्जामिनेशन करना होगा फॉर्म 18 के रूप में। फॉर्म 5 ये चारों एप्लीकेशन फाइल कर दिया विद इन 12 मंथ में। उसके बाद क्या करेंगे कि हम 48 मंथ का टाइम हमको मिलेगा रिक्वेस्ट फॉर एग्जामिनेशन करने के लिए कि हमको मेरा एप्लीकेशन जो है वो एग्जामिन किया जाए। उसके लिए हमको फॉर्म 18 फाइल करनी होती है। अगर हम नहीं करेंगे तो केस अबंडन हो जाएगा पेटेंट ऑफिस में, क्योंकि एप्लीकेंट की ओर से कोई रिक्वेस्ट नहीं आया है एग्जामिनेशन करने के लिए। अगर हमको वो एक्सप्रेस एग्जामिनेशन चाहिए तो उसके लिए फॉर्म 9 फाइल करना होता है। तो एक्सप्रेस एग्जामिनेशन हो जाएगा आपका और पब्लिश हो जाएगा। ये और दूसरा ये है कि अब इसका स्टेप क्या है। तो ये क्या है, फाइलिंग किया कंप्लीट और प्रोविजनल 18 मंथ के बाद हमको उसका पब्लिश हो जाएगा ये इंडियन गजट में, जो कि हर फ्राइडे को कोलकाता ऑफिस से ये पब्लिश होता है इंडियन गजट ऑफिस। ये हो जाएगा अंडर सेक्शन 11A के अकॉर्डिंग ये जो मेरा एप्लीकेशन है वो पब्लिश होगा। फिर 48 मंथ के अंदर रिक्वेस्ट फॉर एग्जामिनेशन कर देंगे। फिर एग्जामिनेशन होगा तो फिर वो जो केस है वो एग्जामिनर के पास जाएगा। एग्जामिनर एग्जामिन करेगा, उसमें फर्स्ट एग्जामिनेशन रिपोर्ट इशू करेगा, जिसमें कि आपको अगर केमिकल सेक्शन है तो उसमें 3D 3E 3P 3D का ऑब्जेक्शन आएगा, 3E आएगा। अगर केस के जो ऑब्जेक्शन होगा वो एग्जामिनर इशू कर देगा और आप एप्लीकेंट को मिल जाएगा। और एप्लीकेंट के पास अगर मान लीजिए आज मेरे को 14 तारीख को 14 मार्च को अगर मेरे पास कोई FER आया है तो हमको 6 मंथ का टाइम मिलेगा रिक्वेस्ट पर FER का रिस्पॉन्स फाइल करने का। अगर हम 6 मंथ के अंदर नहीं करेंगे तो केस क्या होगा, अबंडन हो जाएगा, अंडर सेक्शन 21(1) के अंदर आता है। तो हमको 6 मंथ का टाइम मिलेगा तो हम रिप्लाई फाइल कर देंगे। अगर केस मेरा अगर रिप्लाई सेटिस्फैक्ट्री है तो क्या होगा, केस जो है ग्रांट हो जाएगा। अदरवाइज अगर केस सेटिस्फैक्ट्री नहीं है और तो क्या कंट्रोलर जो है असिस्टेंट कंट्रोलर वहाँ के आपको हियरिंग इशू करेंगे, हियरिंग का चांस देंगे। अगर हियरिंग में अगर रिप्लाई अगर आपको सेटिस्फैक्ट्री है वो तो ऑफलाइन भी होता है और ऑनलाइन भी होता है, वीडियो भी होता है और ऑफलाइन भी जाके आप कर सकते हैं। तो अगर हियरिंग की रिप्लाई अगर सेटिस्फैक्ट्री है तो केस ग्रांट हो जाएगा, अदरवाइज द केस विल बी रिजेक्टेड। और इसके बाद ग्रांट होने के आपको विद इन 1 ईयर तक आप कोई भी थर्ड पार्टी जो है वो अगर उसको लगता है कि ये मेरा इन्वेंशन है तो वो या कुछ उसका इन्वेंशन में कुछ इंफ्रिंजमेंट है तो वो पोस्ट ग्रांट अपोजिशन फाइल कर सकता है ओनली विद इन 1 ईयर, नॉट मोर देन 1 ईयर। 1 साल के बाद वो कोई कुछ नहीं कर सकता। और जब केस पब्लिश होगा विद इन 11 मंथ तो उसके विद इन 6 मंथ के अंदर हम प्री ग्रांट अपोजिशन भी फाइल कर सकते हैं कि ये मेरा इन्वेंशन है, इन्होंने मेरा इन्वेंशन लिया और ऐसे फाइल कर दिया। तो कंट्रोलर उसमें प्री ग्रांट अपोजिशन होता है, उसमें उसकी भी हियरिंग होती है। जो एप्लीकेंट और अपोनेंट दोनों को बुला करके उनका हियरिंग लिया जाता है। अगर सेटिस्फैक्ट्री हुआ, अगर आप एप्लीकेंट के फेवर में गया तो केस आगे प्रोसीड कर जाएगा, अगर अपोनेंट के रूप में गया तो केस वहीं रिजेक्ट हो जाता है।
Right. I think this is the brief outline of patent filing process. Since it is a property, so it is the responsibility of the applicant or the inventor who has to be in line with the procedures. If you file a patent, it is your responsibility to also request a patent office to examine by filing request for examination. Based on their examination, if it is in your favor, if it is in favor, it may be granted. Otherwise, you may be called for hearing. After that, finally, the decision may be in favor or the patent may also get rejected by citing several reasons. And to maintain the patent for 20 years, you need to pay the maintenance fees also. And I hope, thank you, Dr. Seema. You have narrated it. Of course, it was oral, but I hope it would have given some inputs for all the participants.
Yes, sir. Of course, sir. Thank you so much. So I would like to request if any participant is having any query, or we should proceed to the end of the event. If there is any query or any question you want to ask from our eminent speakers, so you are most welcome. You can raise the hands or you can write in the chat box.
Yes, you can ask the queries now, or if you have queries which you wish to ask at a later stage, you are most welcome to write to us by email.
Yes, sir.
At any
So
time.
I will share the email IDs. With
Yes. Yeah, please share.
participants.
Please do share.
Yes, sir. So I think there are no more queries, and we should end this event. So now I would like to invite our head of the department, PG Department of Chemistry, Dr. Manju Sahni, for her vote of thanks. So over to you, Manju ma'am. So I'm sharing the screen.
A very good afternoon to one and all. At the outset, on behalf of KMV IIC and PG Department of Chemistry of Kanya Mahavidyalaya, the Heritage and Autonomous Institution, I extend my sincere thanks to Dr. Seema, Scientist CSIR, New Delhi, today's resource person. Ma'am, lecture was very, very interesting and very informative, and you discussed structure of patent and filing process in a very nice manner. We are really grateful for the time and effort you took to share your thoughts and experience with us. Wholeheartedly, I must thank our principal ma'am for her support and guidance for organizing such events. I am also grateful to Dr. Rashmi Sharma, President KMV IIC, for her cooperation in conducting this 3 days online workshop on IPR. Many thanks to Dr. T. Paman Kumar again. And thanks to the students for their enthusiastic participation. Looking forward to many more such interactions. Thank you very much once again.
Thank you so much, ma'am. Thank you for your words of appreciation. So I would like to thank Dr. T. Pavan Kumar once again and Dr. Seema for sharing their valuable inputs and their knowledge with us. So thank you so much. And thank you all the participants for being a wonderful audience. Thank you so much.
Thank you all. Thank you very much, and wish you all the very best. Thank you.
Thank you, sir. Thank you so much.